We are now going to have Mr. DYMOND to talk with us about courses related to dispute resolution in FIDIC contracts. Perhaps I will first introduce the bios of Tony. And Tony is a partner of the firm Voice and Pimpton LLP. This is a firm based in London and Hong Kong. And he's the co-chair of the firm's Asian arbitration practice. And Tony's practice is mainly on complex multi-jurisdictional disputes in both litigation and arbitration. And he is widely acknowledged as a leading lawyer in high-value disputes arising from large-scale projects, particularly in the energy and infrastructure sectors. He has appeared in arbitrations under the principal arbitration rules and in the English and Hong Kong courts. Now we see Tony face through video. So, so with this introduction, I now pass to Tony to let him talk with us about the courses related to dispute resolution in FIDIC contracts. Tony.
Thank you very much, Graham. Can I just check that everybody can hear me? Graham, perhaps you could just indicate that everyone can hear.
Yes, we can hear you.
Yes. Great, fantastic. Well, first of all, I would like to thank HKIE for inviting me to speak at what is a really interesting and prestigious event. It's lovely to speak at an event in Hong Kong. I lived in Hong Kong between 1998 and 2005, and in my current role, in pre-pandemic times, I split my time between London and Hong Kong, and I'm very much looking forward to getting back as soon as it's practicable. The FIDIC suite is, I think, by far the most important of the international construction forms. It's used across the world, and it informs the drafting of many bespoke forms and many in-house standard forms. FIDIC has long had a focus on dispute resolution. The forms themselves grew out of the old ICE forms, which themselves contained a tiered dispute resolution process in which the engineer initially decided disputes with unresolved matters then proceeding to litigation or arbitration. As I'm sure many of you will know, the 1999 editions of the Rainbow Suite, which is what the principal contracts under the FIDIC forms are called, the 1999 edition introduced the Dispute Adjudication Board, the so-called DAAB, and that was in part in response to concerns in the industry about the independence and impartiality of the engineer who formerly had decided disputes under the contract. And those concerns were driven by, I think, a number of factors. Firstly, the fact that the engineer was engaged by the owner. Secondly, that they act in many respects as the owner's agent, but obviously when they're determining disputes have to act independently and impartiality, and it was felt that there was a tension between those roles. And thirdly, they are often in their role as dispute resolvers, reviewing their own decisions, valuations, certificates, etc. And I think for all of those reasons, there were concerns in the industry that the role of the engineer as dispute resolver just wasn't up to standard, so the DAAB was introduced, as I said, in part in response to that. I'm going to talk principally today about the 2017 edition, which is the most current edition of the FIDIC Rainbow Suite. And for those of you who don't know it, but do know the 99 edition, and I suspect there'll be some here because the 17 edition is still working its way into current use. The 17 edition introduced some, I think, pretty significant changes. Firstly, it leveled the playing field in many respects between owners and contractors. Employer claims and contractor claims now use essentially the same mechanisms, and they're subject to substantially the same time limits. I think that's the first change. The second, and one on which we'll focus today, I think, is that it recast the DAB, the Dispute Adjudication Board, as a DAAB, Dispute Advisory and Adjudication Board. And it drew on wider industry experience with advisory boards, which provide non-binding advice to the parties in construction contracts, so that the new DAAB, which I'll still call a DAAB because it rolls off the tongue more easily, now has a dual role, a dual advisory and adjudicative role. And lastly, but as you'll see, not least, the 17th edition introduced a new series of time limits, which require the parties to comply with those time limits or lose their entitlements to claim if they fail to meet them. And that effectively keeps claims moving through the process. And it means that, you know, employers can't hold up claims simply because determinations aren't made, and that contractors can't decide to park all of their claims until the end of the contract, and then try and bring a sort of massive final account claim. That, at least that is the intention. That's the intention. Whether it works well or not, perhaps we'll discuss in due course. But the number of mandatory time limits that in effect act as conditions precedent to claim has gone up from, I think, 2 under the 1999 edition to 5 under the 17 edition. So that is quite a significant change, and it's something that all of those who manage these contracts have really got to look out for, because there is a real prospect that meritorious claims could be lost simply by people missing time limits. So this slide essentially sets out what I want to cover in the next 20 minutes or so, and because I want to leave time for what I hope will be an interesting discussion at the end. So this slide really sets out FIDIC's discussion about whether and to what extent those aims have been achieved. And I've already introduced some of these. I should say that FIDIC regards the DAAB as central to the dispute resolution process under the FIDIC contracts. It's enshrined, the use of the DAAB is enshrined in one of the so-called FIDIC golden principles, which relate to fair and equitable risk sharing. Now, just pausing there, I don't always agree with FIDIC, and you'll hear as we go through this some of the respects in which I don't, but I do agree with them here. I believe that independent, binding, and enforceable interim dispute resolution is an absolute game changer for contractors faced by recalcitrant owners. And I think amending these provisions, removing the DAAB, and we see that a lot in contracts all over the world, particularly I think in the Middle East, but elsewhere too. But removing the DAAB can massively change the risk profile of a FIDIC contract. You can already see from this slide, I think, that the process is a pretty sophisticated and elaborate one. Some might say it's over-elaborate, as this slide suggests. These are all the steps that a party making a claim for time or money will have to go through in order to get to the ultimate form of dispute resolution, binding arbitration. There is one step in there which is optional, which is step 7, and we'll talk about that in due course. But as you can see, it is sophisticated and elaborate, and you know that contains its own problems and potential causes of delay. For now, what I want to focus on is the fact that this system really has a series of cycles of consultation and negotiation before binding determinations are issued, and that's very much part of the FIDIC philosophy, that parties should have an opportunity or a series of opportunities to resolve their disputes by agreement as the dispute or claim wends its way through the dispute resolution process. And so these are the points at which there are opportunities for consultation, negotiation and agreement. And then, as you see, those are the points where you have binding decisions being made by a neutral third party. And so the system is parties get an opportunity to agree, but in default of an agreement, the third party will make a decision. Now, I'm going to focus in this talk on claims and disputes that relate to time and money. They are governed by Clause 20 of the FIDIC form. Clause 20 of the FIDIC form essentially sets out a definition of a claim and then how claims are to be handled. And it opens by saying that claims are claims for time or money by the employer or contractor, and then it talks about other claims which are referred directly to determination by the engineer under clause 3.7. And just pausing there, the structure of the FIDIC contracts is not always particularly easy to work your way through. So you have this section, this clause 20, which deals with claims for time or money. It then refers back to clause 3.7, which deals with engineers' determinations. Engineers also determine other claims, those that don't relate to time or money, and also other matters which are referred to them for determination under the contract. So I just mentioned that at this point because it's not an entirely intuitive structure. But for claims for time or money, we start with clause 20, which then refers back to clause 3.7, and then if claims are not resolved under clause 20, we move on to disputes under clause 21. And this is quite an important point, at least in FIDIC world, that a claim is not a dispute, they differentiate very clearly between claims and disputes. Claims are part of the mechanism by which scope, price, and periods are adjusted. They are simply part of the normal administration of a contract. They will happen in pretty much every contract, any substantial contract. And disputes arise when parties can't agree or are dissatisfied with the engineer's determination of claims. And in FIDIC world, the escalation from an engineer's determination to a DAAB decision marks the move from a claim to a dispute. And in order to demarcate the claims from disputes, FIDIC have now separated the relevant clauses, with claims being addressed under clause 20 and disputes being addressed under clause 21. So let's step through them. So I'm going to step through the process. I don't want to spend too long on each step of the process because, as you'll see, it's somewhat repetitive. But since many of these steps are mandatory, it's important that we at least illustrate them. So the first step is a notice of claim. It's got to be in writing. It's got to be identified as a notice in order to qualify as such. And it must be made within 28 days after the party, the claiming party, becomes aware or should have become aware of the event or circumstances giving rise to the claim. And it won't surprise you to know that there is in the UK, and I'm sure elsewhere, some authority about exactly what that means when a party becomes aware, or should have become aware, whether it gives a claimant some kind of optionality on when it can submit a claim. This is the first condition precedent. If a notice isn't given within 28 days, then the claiming party is not entitled to additional time or payment, and there's no liability. This is the condition precedent that existed under the old form and has been carried forward. There is, under the 2017 edition, a little bit of wiggle room if there are good reasons why a claim could not have been submitted within the 28-day period, then the engineer can nevertheless determine the claim in that party's favour. The contract specifies what good reasons include, and it includes the counterparty being aware already of the matters having given rise to the claim, and other matters of that kind. But the primary position is that the 28-day period is a condition precedent. If you don't satisfy the 28-day period, your claim is likely to be shut out. This is a new step under the 17 edition. If the engineer thinks you're out of time, he's got to give a notice, and he's got to give that notice saying you're out of time within 14 days of the date of the notice. And if he doesn't give that notice, then the original notice of claim is deemed valid. But it doesn't stop there, because, of course, either party might disagree with the engineer's initial decision. And the contract gives the counterparty an opportunity to note its disagreement with the engineer's decision, and the claiming party also to register its disagreement with the engineer's decision. So already you can see just how elaborate this process is. And then the engineer will then go on to determine the claim, provided, as we see, that a fully detailed claim is then submitted. So next step is that a fully detailed claim must be made to the engineer, and that fully detailed claim has got to be submitted within 84 days from that initial date of having become aware, or should have become aware, of the event or circumstances. There are provisions if the claims are ongoing, if the events are ongoing, to submit interim claims. And then the engineer must decide, firstly consult with the parties, and we saw that earlier, these cycles of negotiation, conciliation, amicable settlement, and then determination. Opportunity to reach an agreement, and if an agreement isn't possible or isn't reached, then the engineer shall make a determination of the claim within 42 days of receipt of the detailed claim. And this is a key feature of the FIDIC contracts, that these decisions are binding and enforceable. If the engineer makes a decision and no notice of dissatisfaction is issued, and we'll come on to those shortly, then that decision becomes immediately binding and enforceable, and can be referred directly to arbitration to enforce the engineer's decision. But either party is entitled to note its dissatisfaction with the engineer's determination, and that's a condition precedent for escalation to the next phase of the dispute resolution process. That's moving, as I said, from claims into disputes. In order for it to be a valid notice of dissatisfaction, it's got to be issued within 28 days of the engineer's determination, and it's got to say that it's a notice of dissatisfaction. And it's got to provide reasons, although I've never seen a notice of dissatisfaction failing on the grounds that it failed to provide reasons or that the reasons were in some sense defective. You can serve a partial notice of dissatisfaction, and then the remaining parts are considered final and binding. And as I said, if there is a failure to comply with an engineer's determination and there is no notice of dissatisfaction, then you can go straight to arbitration to enforce the engineer's decision. You don't need to go through the DAAB process because you have a determination which is now final and binding. So the next step, assuming a notice of dissatisfaction has been served, will be to refer the matter to the DAAB for a decision. Now, the contract itself doesn't say an awful lot about the DAAB. You need to look at the appendix to the contract for that. The appendix to the contract sets out the general conditions for the DAAB, and it governs the obligations of the DAAB members and the obligations of the parties. And it also annexes a set of procedural rules which are rather important. They govern such things as meetings and site visits. There is an expectation that the DAAB members will visit the site at regular intervals, will be kept up to speed on what's happening on the project, will consult with the parties at various points, etc., so that they are meant to be up to speed on the project and able to advise on the project as it progresses. They should be really intimately familiar with the project as a result of those site visits, review of documents, discussions with the parties, and very well positioned to advise. The rules also set out rules about disputes and hearings. And as you can see, there are provisions for what happens if the parties fail to agree on DAAB members, etc., as you would expect. So this slide deals with the avoidance of disputes and the DAAB wearing its advisory hat. I placed this slide at a particular position in the dispute resolution process, but the truth is that the parties can avail themselves of the advice of the DAAB at any point in the project, except when the engineer is carrying out his duties under clause 3.5, actually making a determination on an issue. So I actually think it'd be quite common for the DAAB to take on its advisory role, have matters referred to it, before even matters are referred to the engineer for determination. But it had to go somewhere on the slide, so it goes here. There aren't any time limits on the assistance. You need to remember that time continues to run while the DAAB is acting in its advisory capacity, so there's no limitation tolling as there is with references to the DAAB. This is an entirely voluntary feature of the FIDIC form and wasn't available under the old 1999 edition. I think experience through non-FIDIC projects has been that advisory boards have been very, very effective, particularly on major projects, and it's for that reason that FIDIC wanted to incorporate this into the 2017 suite. But moving on to dispute resolution itself, and this slide deals with that. Parties may refer matters to the DAAB for a decision once a notice of dissatisfaction has been served in relation to an engineer's decision. And the DAAB must issue its decision within 84 days from the date of the referral. Clause 21 doesn't set out much of a procedure for the DAAB's decision making. For that, you need to look at the annex, and the annex provides for the DAAB to act fairly and impartially. It provides that each party must be given a reasonable opportunity to present its case, and it qualifies that opportunity by making reference to the time limits under the contract for the DAAB to give its decision. So there is a recognition that you can't have quite the same elaborate submission, response, counter-submission, rebuttal, surrebuttal, etc., that you would have in an arbitration. But nevertheless, there has to be some degree of fairness and opportunity for the parties to make their submissions on the cases. And the rules also provide that the DAAB should adopt a suitable and efficient procedure. So DAAB must issue its decisions within 84 days from the date of the referral. It must be in writing. It must provide reasons. It's immediately binding on both parties, and they must comply with it, whether or not a notice of dissatisfaction is subsequently given. If they fail to agree, if they fail to make a decision within the 84 days, then either party may issue a notice of dissatisfaction and continue on to the next step, which moves towards arbitration. I should have said, when I said that the DAAB must issue its decision within 84 days, that is obviously subject to agreement of the parties to extend that time. And it's pretty common to see an extension agreed, particularly for complex disputes where the parties think that there's a reasonable prospect that they'll get a sensible decision out of the DAAB, then they may well agree to extend that period of 84 days. If the party doesn't comply with the DAAB decision, then the other party can enforce that immediately through arbitration. It's worth pausing there because under the old form, the 1999 form, there appeared to be a problem in relation to decisions of the DAAB where a notice of dissatisfaction had been issued. The contract provided that they were binding unless and until overturned by an arbitral tribunal, but there didn't appear to be any express provision which entitled the parties to go to arbitration to enforce that interim binding decision. That lacuna, which gave rise to a famous series of cases in Singapore, the Pasero series of cases, that's now been filled. It's now very clear that a party may enforce a decision which is only interim binding because a notice of dissatisfaction has been issued in relation to that decision. And so if you have a decision in your favour that the other party is challenging, you can enforce it in the interim by making a claim in arbitration. Final award, whilst the merits of the underlying dispute being disposed of in the same arbitration. But it's a very important provision that enables the parties to enforce these interim binding decisions. That's really what makes, what gives the DAAB, in my view, gives it teeth and enables it to be used for its originally envisaged purpose, which was to ensure that contractors in particular were able to get proper cash flow during the currency of the project. Again, as I mentioned, we have another set of notices of dissatisfaction. If you get a DAAB decision which you don't like, you can submit a notice of dissatisfaction within 28 days of receipt of the decision. And again, as you would expect, it needs to set out the matters in dispute and the reasons for dissatisfaction. And if you fail to serve a notice of dissatisfaction, then the decision becomes not only binding, but final and binding. So there is then no opportunity to challenge that decision by way of arbitration, though it can, of course, be enforced by way of arbitration. So on to arbitration itself. Once a notice of dissatisfaction has been served, then the parties shall attempt to settle the dispute before commencement of the arbitration, and there's a 28-day period in which no arbitration can be commenced. And the step is stated to be mandatory, it appears to be a mandatory step, but there's no sanction for non-compliance. And what I mean by that is that even if neither party makes any attempt amicably to settle the dispute, there's no preclusion from then proceeding to arbitration. And then the final step in the dispute resolution process, ICC arbitration typically, it can be 1 or 3 arbitrators. Under the old rules, specified 3. Under the new rules, under the 2017 edition, it just refers to the ICC rules, which may provide for 1 or 3 arbitrators, depending on the value, etc. And as you would expect, the arbitrators have full power to open up to or revise any determination or decision, save to the extent, of course, that no notice of satisfaction has been served, in which case all they can do is enforce the decision of the DAAB. So I was very keen to leave time at the end, and I see I've just about managed to do that. What I think that the FIDIC has got right is providing the attempts for conciliation and negotiation. I think that the strenuous efforts to which FIDIC have gone to avoid arbitration are meritorious. I think most of us who do disputes in the construction sector recognize that arbitration is absolutely a final resort. It can be extremely expensive, very time consuming, takes a long time to get a result, and is not where typically either of the parties want to be. And so I think multi-tier dispute resolution process is very much part of the solution for that. And as I've said on a couple of occasions earlier, I think the interim binding dispute resolution which the DAAB provides is an absolute key feature of FIDIC. And I for one, I applaud the introduction of the advisory powers that the 2017 edition introduces. I have somewhat mixed feelings about the introduction of 3 new conditions precedent, the various additional notices of dissatisfaction which need to be served, etc. I think that there are risks there, both that parties simply may miss those as a result of administrative oversight. Nobody likes to see meritorious claims fail simply because a party has accidentally missed a deadline. I also think that there is a risk that disputes will be escalated unnecessarily because the process inevitably drives you to do that. You have to either move forward with your claims and your disputes, or you've got to accept the decision of the engineer or the DAAB, as the case may be. There's no opportunity simply to sit on the decision and think about it and think, well, you know, let's see where we are at the end of the project, and we'll decide at the end of the project whether we want to bring these claims. And so there's some flexibility that's been lost from the process as a result. The upside is that disputes and claims are resolved as soon as is practicable, and it may well be that the benefits outweigh the costs of introducing this sort of fairly rigid framework which drives you through the process. It is extremely complex. And look, I mean, I hope that's clear from the short talk I've provided. And I do wonder whether it is too complex. There are too many notices. I mean, it seems to me that there are too many steps, too many notices, too many opportunities for mishaps. And as I said, you know, the time bars might have the counterproductive effect of escalating disputes. And then just two other comments, and this is not really comments about the contract itself, but really about the use of the contract. The first is that actually we see very limited use of DAABs in many parts of the world. I mentioned that in the Middle East in particular, it's very, very rare indeed to see disputes, to see DAABs used in FIDIC contracts. And the same is true elsewhere, I think. The second and somewhat related point is that it's extremely rare to see enforcement of interim binding DAAB decisions in arbitrations. Now, as I said, I regard that as an absolutely key feature of the contract, that these interim decisions are interim binding and are enforceable unless and until overturned. But my experience is it's very, very rare to actually see parties seek to enforce them. They tend to simply go on and deal with the substance of the dispute in a subsequent arbitration. I asked a fairly substantial audience at a recent conference how many of them had attempted, successfully or otherwise, to enforce a interim binding DAAB decision, and the answer was nobody there had done so. And then the last point, this is not a point which really concerns me, but it's worth raising. The DAAB, as I said, has got two roles. It has an advisory role and it has an adjudicative role. And I think some users perceive a risk that there is a tension in those two roles. You know, if a DAAB has already advised on an issue, is it really likely to come to a different decision when it takes on its adjudicative role? Might it have heard things through its advisory role from one party or the other, or from simply being on site, that have informed its decision in its adjudicative role, and so that that sort of quasi-judicial role has somehow been tainted by its mediative role? I have to say, that's not something that particularly worries me, but it's an issue that has been raised by others. I think that's it from me, but I'm really keen, and I see I've overrun the time I expected to take on the talk, but we do have a little bit of time left for questions and discussions.
Thank you, Tony. I have a follow-up question with you on the condition precedent point. Now, you have mentioned that for the notice of dispute that has to be raised within 28 days of the occurrence of the event or reasonable time after the detection of this. And that's, according to you, is a condition precedent. But yes, there is also a requirement for provision of particulars of laws, and that, according to what you said, should be provided. Is it a condition precedent, or what? Or it's given a different tier of consideration?
So I think the question, Graham, was, well, what happens if what's regarded as a condition precedent under FIDIC? That there may be local laws which render that ineffective,
yes.
or at least there's a tension between local laws which say, look, notices don't generally act as conditions precedent, and the contract which says it does. And look, that's an issue which we come across very commonly. Again, it's an issue which comes up a lot in the Middle East, but I think it comes across generally in civil law jurisdictions where good faith, abuse of rights, those sorts of doctrines are very important. And you often then get disputes about whether or not a provision in the contract which says it's a condition precedent actually takes effect as one. Certainly I've been involved in Middle East disputes where failure to comply with the time limit under the FIDIC contract, which was stated to be a condition precedent, so the notice of claim under clause 20, was not regarded by a tribunal ultimately as lethal to the claim.
I see. Thank you. There are some questions from the floor. The first one is, what are your experience of using FIDIC contracts on mainland China projects? Now, Hong Kong is participating in the GBA development. So what is your advice to Hong Kong engineers on their roles in dispute resolution under FIDIC contracts?
So look, first of all, confession, I haven't done any disputes on FIDIC contracts on mainland projects. I have negotiated and drafted FIDIC contracts for mainland projects some time ago, but I haven't actually done any mainland disputes under FIDIC contracts. But look, my advice generally for managing these, for running these contracts, is that they're very sophisticated contracts. They've become more and more sophisticated and more elaborate. And they really require a project management team on both sides, both the owner side and the contractor side, that really understand the contract, understand the time limits, understand the route through the claims process, which is not straightforward. I started by saying, look, you've got this thing, clause 3.7, which is engineers' determinations, but that is essentially a funnel for claims for time and money. It's one type of claim. Other claims under clause 20, what are described as other claims, and also other matters under the contract, which are referred to engineers' determinations under 3.7. It's quite a complex and not an intuitive contract. And I think as it's become more sophisticated, it requires, more and more, contract management in order to ensure that, time limits are met, that particulars are given, and that both sides, who generally want to deliver the project, properly, on time, on budget, and comply with their obligations, actually are able to do so, because if they don't know what their obligations are, then they're on a hiding to nothing. So I think that would be my advice to anybody running a contract under the 2017 edition. This is a very sophisticated contract, and it requires a team which is equally sophisticated in its management.
Yes, thank you. The last question is, if employers use their own standard form and risk allocation, how can this be negotiated and allocated to the party best placed to manage that risk?
Well, look, I think the answer to that is it can't, really. We see contracts all the time. it's typically owners who decide the form of contract to be used, and very often we see extremely one-sided contracts that don't provide for adjustments, for financial adjustments for a whole range of, sort of neutral type events, ground conditions, weather, etc., those sorts of things. They say, well, that's just all the contractor's risk, and don't provide for interim binding determinations, which, as I've said, I actually view as a sort of major part of the sort of risk allocation in a contract, the ability to actually get enforceable decisions as the project moves forward. But we regularly see contracts without all of those things, and then contractors have just got to decide whether they're prepared to bid for those projects and what price premium they're going to place on the risks that they're being asked to carry. Personally, I think it's short-sighted of many owners to have very one-sided contracts. I think they probably don't get the range of bidders that they would otherwise get, and they almost certainly get higher prices. It's amazing how creative contractors will be down the line at dreaming up bases of claims, even if the contract appears to be very one-sided. So it may not even get the employer what they want at the end of the day. I guess that's it. If employers insist on using their own form and insist on a risk allocation which is skewed towards them, then that's of course their prerogative. They will end up paying higher prices, and they may not avoid claims.
Thank you so much. Thank you, Tony, for sharing with us your knowledge and taking us through the FIDIC contract on dispute resolution. I am sure that both the attendees and I have learned a lot from you on this FIDIC mechanism. Thanks so much for spending your time with us.
Thank you very much.
Now, we wish to thank Tony by using our usual way. Thank you, Tony.